Afternoon, everyone. I am Kristin Hausler. I'm the Dorset Senior Fellow, and I lead the Center for International Law here at the British Institute of International and Comparative Law. And it is a great pleasure to welcome all of you who made it despite the rain here today. Thank you for joining us in person. And we have also over 200 people who registered online, so welcome to them as well. I do also encourage those participating online to submit their questions along the way. We'll be looking through them, and we will have time for a Q&A discussion at the end. I am extremely pleased today to welcome our panelists. We'll discuss a very important topic, a topic that is often seen as a bit niche by international lawyers, but it really cuts across a lot of very important international legal issues: state responsibility, accountability, reparations, but also human rights. The right to access and participate in cultural heritage and enjoy cultural objects is now recognized as part of human rights. So that's something perhaps also to keep in mind during the discussion today. Last week, I was in The Hague. There was a big anniversary event for the 70th anniversary of the Hague Convention for the Protection of Cultural Property in the event of armed conflict. And of course, since 1954, since this convention was adopted, there has been a lot of initiative to protect cultural property in times of armed conflict. But of course, we shouldn't forget that a lot of objects were pillaged, were taken under duress in situations of conflicts or other situation of inequalities well before that time, and solutions should still be found. So I am very delighted to have experts here on this panel to discuss these issues that really cut across a lot of international legal issues that we discuss quite often here at the Institute. As you will see, Anne Weber unfortunately could no longer make it due to unforeseen circumstances, and she is sending her apologies to all of you today. We have also Dr. Chipangura, who you can see online. He's joining us from Manchester. Unfortunately, couldn't also make it today as he's preparing for a big Africa Day later in the week. For all those in Manchester, consider also attending his event. But thank you also for participating, even if only online, hopefully in person another time soon. I will leave Pierre Valentin, our esteemed chair, introduce our panelists in due course. But of course, I wanted to take this opportunity to say a few words about him. I am sure many of you already know him well, as he has worked for over 3 decades in the area, advising art collectors, advising art businesses in all questions relating to art law. He has worked at Sotheby's, at Withers, at Constantine Cannon, and now he's with Fieldfisher. Very importantly as well, today we have the support for convening this event, for offering you this discussion, the support of Restitution Partners. That's an initiative that was launched by Pierre, along with colleagues that are also on the panel. Till and Isabel, they may want to say more about this initiative, but they advise all of those that have a dispute over cultural heritage in facilitating, in looking for solution in a confidential manner, a solution that are both just and fair. So we're very grateful to Restitution Partners for having so closely cooperated with us for this event, and hopefully for other discussion in the future as well. So I will now leave it over to Pierre and to our panelists. Thank you.
I'll stand briefly and then I'll sit down, I promise. Thank you very much, Kristin. I'm thrilled to be here. Thank you for those who braved the rain to come, and welcome to those who are joining us online. Protocol quickly, please make sure that your mobiles are switched off, and you will be invited to ask questions, both those attending here in the room and those attending online. If you have a question, it would be lovely if you could say who you are before you ask the question. Turning now to the next 2 hours that we'll be spending together, I would introduce our panel of today. The way we're going to handle this is each panelist will make a very short presentation, so not standing, sitting down, on a topic that's close to their heart. and hopefully you will find informative and relevant. And then there will be a panel discussion, and of course you will be all invited to ask questions, and we'll do our very, very best to answer them. So to start with, well, I should say this is a multi-continental, multinational panel, and I'll start with our colleague from beautiful country, continent of Africa, Dr. Njabulo Chipangura, who is joining us online. Hello, Jabu. Jabu is a curator of living cultures at the University of Manchester Museum. He has a PhD in anthropology from, forgive me the pronunciation, the Witwatersrand University in Johannesburg. I hope I got this more or less right. Jabu has published extensively, and his first book, called Museums as Agents for Social Change, was published by Routledge in April 2021. You can find it on the website of Routledge. You can buy it there. It's been published in paperback, which is a sign of success, I think. So congratulations. Dr. Evelien Campfens, very good to have you with us. Evelien is well known in the area of cultural property law. She, for 13 years, I think, you were General Secretary of the Dutch Restitution Committee, coordinating the research and procedures of well over 100 claims to Nazi-looted art. And you've also published, and you're also board of trustee, I should say, of the German Lost Art Foundation. You've published extensively, and you, I looked at Amazon to see if I could buy your book. Well, first of all, you published a wonderful book called Fair and Just Solutions in 2014, which is out of print, according to Amazon, which suggests that it's been a huge success. And your latest book is called Cross-Border Claims to Cultural Heritage, published in 2021, which is available to buy on Amazon. Isabel von Klitzing, to my left, is a qualified lawyer and one of the top provenance researchers in the world. She was a senior restitution specialist at Sotheby's for many years before starting her own business, focusing on provenance research about 12 years ago now. Welcome, Isabel. Thank you for being with us. Till Vere-Hodge at the very end there. Till and I used to work together. We no longer do. Till is now a partner at Payne Hicks Beach in London, and an expert on all things related to Nazi-looted art and many more. A preeminent art lawyer, I would say. And finally, Robert Peters, who joins us from Germany. Robert sits on the legal, let me get this right, on the Legal Affairs Committee of ICOM, the International Council of Museums. He also works for the federal government Commissioner for Culture and Media in Germany. And you have a PhD from the European University Institute in Florence. I tried to get in there. They rejected me, so so you did much better than me. So that's our panel, and I would like to invite each panelist, starting with Till, to give us a short presentation, a few minutes. Over to you, Till.
Thanks very much, Pierre. I hope everyone can hear me properly. I would like to start by setting the scene a little bit, and giving you my thoughts on the topic, which is, of course, from spoliated art restitution to colonial-looted art repatriation. In that context, I think it's fair to say that Nazi-confiscated art claims and the framework that has developed there too is probably the most advanced such framework. But even so, it is absolutely not straightforward. And some of the particular challenges include the scale and context of the looting that took place in the context of the Holocaust, of course, the passage of time that has elapsed since the looting occurred, the limits and limitations of applicable legal remedies as a result of that passage of time, the relative vagueness of the moral claims framework that has developed in order to address those limits and limitations, and the fact that hardly ever are any two cases the same. However, when comparing this complex field of Nazi confiscated art with other categories of looted art objects, what is clear, I think, is that actually Nazi confiscated art can be relatively well defined in some ways. For example, Nazi confiscated art claims generally relate, well, they always relate to claims to artworks that were dispossessed in a mere 12-year period, i.e. between 1933 and 1945. They are generally understood to relate to dispossessions that have occurred in geographies under the control of the Axis powers, although there are, of course, exceptions to that. We won't go into Fluchtgut and such topics, but generally speaking, it is by time and by geography relatively clear what we're talking about. If you compare that starting position with that of colonial-looted art, for example, conceivably, you're talking about any time in recorded human history wherever there was some form of external domination, and conceivably, it could have happened anywhere in the world. So from the outset, you see that while it is a very complex and challenging area, it is still more clearly defined, perhaps, than other categories of looted art objects. In addition, Nazi confiscated art very often, but not always, of course, relates to private persons or families being the claimants, whereas colonial looted art, for example, generally relates to either state actors, intrastate groups or communities, or diaspora communities. So while Nazi confiscated art claims may, let's put it this way, benefit from more clearly definable parameters, even this framework is far from complete or perfect. And it always depends on a case-by-case analysis, which is something that, in particular, I think is fair to say, Pierre and Isabel and I have always found when working together on these sorts of cases. So therefore, it would be very wrong, I think, to expect an easy fix for any category of looted art claims. In fact, experience has shown us that you really need to consider each case individually, take account of all relevant facts, and look at the full provenance of artworks and the artworks in question. And just by way of an illustrative example for this, for example, in 2018 at the Berlin conference on the 20th anniversary of the Washington Principles, I had the pleasure with Isabel to do a workshop on air search and genealogy. And I'm just mentioning that because I think it illustrates very nicely that is absolutely crucial, not only for the heirs and the claimants to be clear about that aspect, but also, of course, for collectors and collections, because you want to manage the risks and liabilities that can come even from finding a resolution. Of course, it is, very embarrassing and, of course, legally tricky if you settle with who you think are the rightful heirs, and later on it transpires that there are other potentially additional heirs or rival heirs coming out of the woodwork, for example. So all of that also has got to be dealt with in a diplomatic and sensitive way, and unnecessary conflicts are always best avoided. because an amicable outcome is usually in the interest of all parties involved. So the key takeaways, I think, from all of this can be neatly transferred from, what we have learned, or what has been the sort of established way in relation to Nazi confiscated art claims and the resolution of those, and applied to other areas of looted art claims. But the parameters may be quite different, and one-to-one solutions are not necessarily transferable from one field to another.
Thank you, Till. Before I pass the microphone to Evelien, one comment and one question. I mean, you just mentioned the importance of identifying who the heirs are. Of course, there is, I mean, I read recently that the Klimt that was sold in Austria by Im Kinski, after the sale, an heir came forth who apparently was not included in the settlement, which of course, I suppose is quite a big problem for the auction house, certainly, and the buyer, who ends up with an expensive painting and a claim, effectively. Now, you focused on Nazi looted art and colonial or art looted by the colonial powers. It's a much broader area, of course. What else? What are the other categories of restitution claims that we could think of?
Yes, I think that's absolutely right. So, of course, the headline of today's topic picks out two particular aspects, but there are many others in between and beyond. So, you mentioned one other example where, by the way, I think the handling of communications as well is key, which is another point that is really transferable between all aspects of looted art claims and the handling thereof. Because of course you don't want an artwork to be burnt, or you want to have disputes being fought out in public over certain resolutions that may or may not have been found. But in terms of other categories, an obvious one that crops up a lot is, of course, antiquities looted from sites. And for example, a few years ago, we had the sale of the Saint Laurent sale in Paris, I believe, where two heads that were looted from the Summer Palace in Beijing during the Opium Wars were offered up for sale at auction. And that caused, of course, issues. Another example is one of antiquities, is one where we work together, Pierre, on the Persepolis relief, which was seized from a London dealer in New York in 2017 while it was at a fair, and which was looted in the 1930s from Iran, and which had to be returned. Allegedly looted, sorry. So apart from these antiquities, I think there are other perhaps less well-known categories that may already have cropped up or may continue to crop up, such as so-called GDR-looted artworks that were dispossessed in Eastern Germany under the communist regime there, a Bolshevik looted art during the early years of the Soviet Union, World War II so-called trophy art, for example, Cuban dispossessions, or more current conflicts that will certainly feel the effects of in years to come, such as in Ukraine, Nagorno-Karabakh between Armenia and Azerbaijan, or for example Syria. So there is a whole range of past conflicts, past dispossessions and looting, and current ones that may very well lead to cases in the future.
Thank you, Till. Evelien.
Sorry, could you perhaps help me, because I cannot. I cannot reach the start. Apologies. Yes, so, well, thank you for this invitation, and going further and complicating things further. Actually, I didn't read the title very well, because I am going to start with illustrating. So I'm trying to have some common problems. All these categories are self-contained areas, and there are huge differences. However, I think also it's, as lawyers, it's our task somehow to find commonalities and find solutions also. So just to illustrate the problem, that it's not just limited to Nazi-looted art or historical cases, I just wanted to take this example of a Chinese Buddha statue with a special feature. Mummified Buddha inside of the 11th century, and it was stolen from a Chinese village in 1995, so that's not very long ago. And it was found in the hands of a Dutch collector in 2014, who had bought it in Hong Kong, saying that he was in good faith, because at that time there was no provenance research. And then the claim was made before the Dutch court. We have a civil law system, so that's a huge difference with the American common law system and the British perhaps. And we also only access to the UNESCO convention, the 1970 convention, in 2009. So the judge said, well, there's no base for this claim, and the Dutch possessor is the lawful owner according to Dutch private law. But then for us, Master Zhang is our family. We have had him with us for 1,000 years. So this, I think, captures very well the essence of these claims to restitution claims that you can see in Nazi-looted art, in colonial takings, but also in these kind of cases, that it's not just about stolen property, but it's about symbols of an identity, and it's about bringing heirlooms back to their families. That's how also the field of Nazi-looted art started. And the same colonial takings, taking them back to community. So regular private law is simply not doing the job very well and doesn't reach the essence. And I think that's it's a common point that you can say is valid for many categories. And that is because in legal reality, ownership of goods is a matter of national private law. That differs widely per country, often favoring local interests, with many variations on the theme when and how title passes on to new possessors. And this causes for this paradox of lawfully owned looted artifacts, which generally is felt as unjust, giving rise to the extra legal ethical model that we have developed in the field of Nazi-looted art, and we see now also in the field of colonial takings. That on its turn results in vague standards and ad hoc political decisions. And in my view, we can witness that also in the field of Nazi-looted art, where under political pressure, decisions are made. Now, interestingly, in the Chinese case, after the Dutch rejection of the case was brought before a Chinese court. And the Chinese court said, well, it's not Dutch law that has to be applied here, it has to be Chinese law. So they said it's a special conflict of law rule that the lex originalis should be applied, not the lex not the law of the place where it's found. And so Chinese law applies, and this means it's inalienable. It never could pass on in ownership, something that is similarly true also, of course, for many, well, communal owned property. So it's not so much a matter that there is no law, it's a clash of laws, I think. And the question is, we need international norms, and there are modern day conventions, of course, but they're not retroactive. And even if they're there, countries may not have implemented them, etc., etc. So, so here you see a development, which I think is very interesting, that the law of the country of origin becomes more important, because actually the Chinese, there was an appeal, and you can find it in other legal instruments. And I think also you may say that the ruling of the European Court of Human Rights, only last week's ruling or 2 weeks ago, basically confirming the right of Italy to confiscate or to have a confiscation order of the victorious youth statue in the Getty Institute in LA. Basically, also you can see this as a confirmation of the applying of the law of the country of origin. And this obviously will have major implications for the legal status of artifacts in collections. So it's not only anymore an ethical issue. And this also means that due diligence in terms of provenance research will gain attention, will be not only as an ethical imperative, but also as a legal imperative. Nevertheless, there are all these open questions. So what exactly, for example, is a good provenance? The framework is extremely fragmented. And what was okay some time ago, we can see this in the field of Nazi-looted art, is not okay anymore today. So here I refer also to vluchtgoed cases. And what is a fair solution? Should it always be full restitution of ownership, or is access or control also a solution? And what about all the unprovenanced artifacts, the so-called orphan objects? So I think that in this field, urgently public guidance, procedures in terms of procedures and standards is needed. And here I think that a second important lesson can be learned from the field of Nazi-looted art, that if both standards on what exactly is a good or bad provenance, but also neutral procedures are lacking, which is the case at least in civil law, European countries, ad hoc politics and commercial interests eventually set the tone in what is fair and just, not per se justice. So this causes for legal insecurity and remains an incentive to the illicit trade. So since justice is a public task, I therefore would like to suggest public guidance is needed on what can and what cannot be lawfully owned and traded. Norms are not settled and legislation may not yet be the best path in this highly complex field, although the introduction of mandatory due diligence standards for the trade, as is done in certain regulations, would speed up things. But even then, or perhaps especially then, in my view, the setting up of a publicly funded European authority provenance research that offers guidance and neutral alternative dispute resolution for parties that cannot agree on what is fair and just is of primary importance. So that is actually what I also recommended in this report I wrote and I published, or that was published by the European Parliament. They asked me to give an overview of the problems and come up with recommendations, and that's really nice. So I think that this would be a pragmatic way forward to solve certain problems. So, thank you. If I went over that, I'm sorry for that.
Thank you, Evelien. Before I pass on the microphone to Isabel, one comment and one question. You mentioned a clash of laws. I think what strikes me is that we're so used to the concept of owning object or property that we sometimes forget that for ancient cultures, the idea that you own a representation of a god or an ancestor is completely alien. And I don't think that our legal systems, at least in Europe and in the US, take that into account. Anyway, that's my opinion. Now, considering the various categories of, that Till has described, and you have too, what do you think are the key obstacles to restitution?
Yeah. So I think, by the way, that there, of course, also in Roman law, you had religious objects were extra commercium. So we have it for our own cultural objects. We have this in all cultures, in all legal. Just that when it passes borders, it loses that protected status.
Yes.
So it's from heritage, it becomes a possession. So the main common problems I see, first of all, this fragmentation of the law, regulation. It's not, again, that there is no law, I think. There are standards, also there are international standards like Kristin. Importance also of the right to culture, the right of access to culture. I think that's very promising. So anyway, that fragmentation, and on the other hand, also the fact that lawyer, I found it quite interesting to see that objects are not always identifiable. They're not registered anywhere. You can buy a second-hand car. You cannot buy a second-hand car without registration. So this means that the looting doesn't stick to the object. Very difficult sometimes to make a distinction between bad objects. So I think that's a major practical problem that should be addressed also.
Thank you very much. Isabel.
Sure. Start with a quick thank you to Kristin and her team, because originally we wanted to organize the conference already in 2021, and at the time I was still based in Senegal with my family, and I was really looking forward to, you know, a combination of these topics in one conference. And so yeah, thank you very much to have organized it now, and on behalf of everybody, I think, especially restitution partners. Yeah, so I'm working as a provenance researcher, and it is very hard to compare the historical context of Nazi looted art and colonial cultural theft. But provenance research in both fields shares the same goal: first to identify problematic artifacts and then to seek solutions to right historical wrongs. And since I'm mainly acting on behalf of the current owners, private collectors, the art market, or private and public institutions, I would like to discuss today's topic from this perspective. So first, the identification of potentially problematic objects through provenance research. I think I would like to take a very positive approach. I think that great achievements have been reached in the last 24 years. That's when I started to work in this field. And I would really like to, yeah, I think there's an expanded consciousness of all players in the field, like the art market, museums, and private collectors. I can see in my practice that there is a growing number of private collectors who is seeking, or is at least considering, to have their collection or single objects researched or even audited, and who are also prepared to take consequences if necessary. I think we also have to stress like where we are now in a positive way. Many objects from private collections only come to light once they are offered for sale or given on loan for exhibitions. And today, no serious auction house or dealership would knowingly offer works which might have been looted during the Second World War. To give you an example, for like the German art market, in 2023, there have been like around 25 settlements being reached by the main German auction houses, which is compared to the number of cases, for example, which were before the German advisory committee. They had like 23 cases in, I can't remember how many years, 25? Was it the same year? Yeah. So I mean, they are pretty active, and I don't have numbers for the international auction houses, but I'm sure, you know, I mean, I know from my experience that there are also settlements being on a very regular basis, which shows that the art market and especially auction houses are playing a very important role to identify potentially looted objects in private hands, and they are serving as a mediator between the consignor and former owners and their heirs if necessary. So how can you find equitable solutions? As Evelien and Till have already mentioned, there is no legal framework, which is in a way, from my experience or our experience, sometimes can also be positive, because it allows very differentiated solutions and voluntary decisions. Problem is, however, and that has also been mentioned twice already, that metrics are changing regarding the evaluation of certain facts, for example, for Fluchtgut objects. And the question is still if they should be treated the same way than other looted items. Although the Washington principles are not directly applicable for private collectors and the art market, they are serving as an orientation aid for their actions and decisions. So here's my first slide. You see some rules from the Terezin Declaration. That was one of the follow-up declarations after the Washington Principles in 2009. And as you can see, private collections, private institutions are mentioned. And in number 2, you can also see that that it's stressed that for private archives and the publication of private records, the privacy rules have to be respected. Then we have the so-called best practices, which were published very recently, only in March this year, by the US Department of State. And they are seeking to define the Washington Principles further, taking into account the experience of the last 25 years. For now, it remains to be seen what authority they might have. They seem to be more discussed in Europe at the moment than in the US. And it, to me and to the colleagues I have spoken to, it seems rather unclear by whom exactly they were drafted. It's not a very transparent process. So to show you, yeah, this is here are two rules from these best practices from March this year. Private collectors and private archives and dealer archives are again being mentioned, and also the research by private bodies. But this time, privacy rules and regulations are not being mentioned. If we compare the Washington Conference principle about finding a fair and just solution, and the same rule now, as you know, being like more specifically defined in the best practices this year, you can see that it says the best practices say that just and fair solutions first and foremost should be fair and just for the victims of the Holocaust and other victims of Nazi persecution and for their heirs. And this sounds as if there would be some sort of order of priority, and that the interests of the current owners might not have the same weight than the interests of the former owners. Evelien talked already about justice, and justice needs to be accessible for all parties, which would mean that both parties here need to be treated in an equitable and fair way, taking into account their respective position in order to come to a balanced solution. As Till said, each case has its own merits, and private owners can also have legitimate interests in an artwork, as they often purchased it in good faith or inherited it and looked at it and after it for a substantial time period. So when practice, well, maybe I go back. I don't know if I have it, but I'm just talking about it. There is practice G is also part of the best practices, which is asking to make private archives available online and publish private inventories. I would say that this does also not correspond to the nature of most private collections and is not really realistic. So it seems as if the best practices seem to be rather a desideratum from the claimant's perspective than best practices for all parties involved. Give an outlook from my practice, I would say that it would be better to join forces to reach the mutual goal, to find equitable solutions. And for this, the discrete character of private collections and the art market need to be respected in order to encourage private collectors to do more research and eventually come to settlements. So such guidelines and definitions should therefore be drafted by representatives of all parties involved to make sure that their relevant position will be heard, considered, and addressed. This is also important with regard to, for example, the envisioned framework evaluation for the planned German Arbitration Commission, and also with regard to potential guidelines for other contexts of looting. And to close my statement, I'm coming back to Senegal, where I did an interview with a very esteemed Senegalese colleague, Malik Ndai, who is running the Musée Théodore Monod at Dakar. And I met him many times when I was in Dakar, and I felt that I would like to do something with him that reflects a little bit where both of us come from, like, you know, someone who is dealing with African objects and me dealing more with Nazi loot. And so we decided to do an interview together and to put like my perspective in the questions and his perspective in the answers. And what he said here is, I was asking him if like guidelines like the Washington Principles on Nazi confiscated art, if he would be in favor of such guidelines for the colonial context. And he said, and I quote him, "It would be very positive to have such international guidelines today." Oh, now I can't see the red. However, an equilibrium between African and European experts would be crucial to make sure that such guidelines will be drafted in a balanced way. The discussion needs to take place on a truly international level to achieve a mutual terms, references, and parameters also reflecting the vision of the African countries. And I think what I feel a little bit as, you know, like thinking or looking at the side of the current owners, and which are often private collectors or art dealers, auction houses, I think that it's good to make sure that that side also, you know, like that both sides really are being looked at, and that both sides are being asked while drafting such guidelines and definitions. Thank you.
Thank you, Isabel. I think what you're describing quite well is what I call, or many people call, the tale of two victims.
Mm.
The party who was dispossessed, you know, during, you know, what everyone calls a genocide, and then the person or the party who bought an object in good faith, probably many years later, and looked after it, you know, well. And what you're saying, I think, is that the balance has gone a bit too far one way, and you would rather that the balance be a bit more balanced. I mean, on the other side, you mentioned private collectors. Who else? What are the stakeholders on the other side of the balance?
Well, I mean, I think it's, yeah, as I said, it's private collectors, it's all current owners, really. It's also, it's the art market, it can be museums, of course, public, private.
Mm-hmm.
Yeah, that's...
Okay, thank you. Robert.
Yes, thank you very much. And thank you for inviting me, for having me here. I always, you know, with these kind of talks, I might always think back, and you mentioned my PhD I did years ago in Florence. And of course, if you study law in Florence, you cannot escape the art because you just are, you're falling into it after every second corner. And I just, you know, I'm happy to share how I started working on this, because I still remember it was a day 2005 I was sitting in the sun reading a newspaper, not the political section, the art section. And I read an article about how this was 2005, how the Italian government is trying to get back certain works of art from the Getty Museum, from other US American museums, the Metropolitan Museum and others. And I was so intrigued by this article because it did not mention law at all. It was about the political pressure, diplomatic channels, and the threat of the Italian government. And of course, as you know, most public museums are government museums in Italy, and the threats by the Italian government. If those private museums in the US do not return the list of the objects, there will never be a loan of objects from any Italian museums to US museums. And of course, this is a political threat you don't want to play with. So the Italian government has been successful. They made, I think it was 3-4 years later, a huge exhibition in Rome. As a student, I was lucky to go to Rome to see the objects that have been returned from the US museums on a voluntary basis, because this was the objects that were taken out of Italy prior to the 1970 UNESCO convention, So this was my background in starting digging into the law, because in law school, we did not learn anything about cultural heritage law. And of course, it's still a niche, but my impression is, if I look back 15, 20 years ago, it's getting bigger and bigger. And the cases are not getting smaller, but there are more cases every year, in my impression. So anyway, I started digging in this topic. There must be legal grounds, not only diplomatic channels and political power, because of course, Italy and the Italian museums, they have this political power, but not every state has such a power in art and denying loans of certain art objects. So I started working on my PhD, and the title was Beyond Restitution. And I still believe, after about 15 years now, I still believe that there is beyond restitution, because it's not a one-way street. And therefore, I was intrigued when, Kristin, when you invited with lessons learned and ways forward. So what are the points that we actually can look at, the common ground? What can we take from all? Of course, we have different sets of cases. We have different stakeholders involved, private, public, states, communities. But what were the common grounds? And so when I started working as a member of the ICOM Legal Affairs Committee, we started thinking, okay, how can we assist museums, and not only public museums, but also private museums? How can we assist museums in dealing with those cases? Because in my practical experience, very often, and it's not a case of only big museums, but it's also small museums, they are very often afraid of dealing with certain cases. They do not know how to reply. And very often it's just a matter of giving them a way forward. So what we are right now doing at the Legal Affairs Committee, and I'm one member, it's a committee of 9 lawyers working for the International Council of Museums. And we are working on kind of a key, what key aspects you have to look at, what should be considered as like a checklist. And when we start working, we thought of a one-pager. And as you can imagine, it's still a work in progress. They are not published yet. As you can imagine, once you start talking about the subject and you consult colleagues, it's not going to be a one-pager. So I don't know if we end up with 4 or 5 pages and then we have an annex. But we want to have something clear and precise in order to assist museums, because this is what ICOM is for. What legal grounds are there? What ethical grounds are there? Because very often, I mean, we do have legal grounds. Sometimes they are applicable, sometimes they are not applicable. But what are the moral grounds? What are the soft law mechanisms? And of course, one element gets bigger and bigger, which is due diligence. The most recent decision by the European Court of Human Rights in the Gettybronze case has been mentioned, which brings me back to my early studies. And due diligence is the key factor. And this, of course, applies not only to public museum, but also to the art world. Things that you could have bought easily 30, 40 years ago, nobody would even consider buying them today, because you might hide them in your bedroom, but you will not be able to resell them on the market, because an object without a provenance or without a sufficient provenance, the value I would consider zero, because you cannot put it on the market. You can, but you will fail. And so this is an interesting development also in legal aspects. So we do not only have the 1970 UNESCO Convention and the Unidroit Convention, but of course we also have, it's funny to speak about this in London, but we have European law and EU regulation that have very, very strong due diligence elements, and import regulations that have been adopted by the European Union 3 years ago, and that will enter step by step on an electronic basis within the next 2 years, so that objects that enter the European Union market area have to be registered. So anyway, due diligence is the biggest key element. One of the elements that we are trying now to put in those checklists, in these key elements to assist museums, is use the open channel. I mean, very often it's easily said, just, talk to each other. What are the common grounds? Negotiate. What are the interests of the other party? Because return does not mean it's a dead end. Return mates, I always say, let's make the cake bigger. It could be, the starting point of a relationship, of having loans, of replicas, of a joint cooperation, especially when we talk about objects from colonial contexts. Nowadays, no ethnological museum in the West can do an exhibition without consulting their colleagues in the Pacific, in the African, in the global South. So there is already the cooperation and working together. So why not using this also in restitution cases? Because from the cases I have been working on, and before I worked on the Legal Affairs Committee, I also have been with the ICOM Ethics Committee, and this committee has been approached with confidentially. Sometimes, they didn't mind going publicly with certain restitution cases. But of course, the question was always, so what's the next step? How can we, come to a solution? And one element was always to look what are the elements for both sides that could be interested. And very often, making the cake bigger means you give an object you receive it, and it's the recognition, very often, as not only with communities, but it's the recognition of the fact that this object was, and then, of course, it's a legal question, how do you find it? Stolen, or it was looted or whatever, but it's the recognition of, and I'm not necessarily saying a legal title, but it's the recognition that there was a past wrong. And once you start doing this step, that there was a past wrong, and you try to correct this past wrong in an open dialogue, in an open cooperation with a community, with a museum partner, with a foreign country, then this is the ground, at least from my experience, the cases I've been working with, this is the common ground for really having a successful outcome. And so it's, so this is one, dealing with those objects in an open manner. The second one is maybe there's no quick answer. Very often, there's government pressure there's, next year there are elections, so let's return this before. Or, a private collector or an auction house, we want to go on auction in July. So do your provenance research, you have two months. No, very often there is no quick answer. It needs time. And just because very often a Western museum or Western collector is ready for return, doesn't mean that, for example, the African colleagues in African Museum is all ready to return, you know, especially, for example, I'm not opening up a new box, but I think it's worthwhile mentioning human remains. Certain human remains have been in Western museums for 100 or 120 years. And now we expect that certain countries or communities take them back within a couple of months. They need to prepare as well. So, you know, it's also what you both mentioned before. What's the interest of the other side? So there's no quick answer. And last but not least, maybe as a third point, and maybe this is maybe art historians will kill me for this, but very often the story of an object is much more interesting than the object itself. I mean, this is, you know, debatable, but very often it's not the, I mean, there's this Western obsession about the originality of something. But the story, you mean, if you have a perfect replica, 95% of the museum visitors are not going to even recognize that this is a replica. But they will read, if they, you know, are interested, they will read the story that is behind an object. And this very often, this is very, very interesting, because then you can tell the story of a communication. You can tell, you don't have to hide provenance. You can put it out there because that's the interesting story. And sometimes your story is that there is still a lack of provenance. Well, tell this, and maybe you eventually will find, you know, a little puzzle that the missing link by, you know, recognition of the audience, because, and this is maybe my last word, a restitution claim is not going to go away. This, you know, because museum directors in the 50s and 60s, they have been sitting on their objects hoping, you know, certain debates will go away. No, those debates are stronger than ever. Thank you.
Thank you, Robert. And I'm really fascinated by the concept of, you know, what you call beyond restitution. I think more focus should be placed on that. I'm dying to ask you a very difficult question, but before I do that, I would ask Njabulo, I will hand over the microphone to you, the virtual microphone. The virtual microphone doesn't seem to be working.
Oh, sorry. So can you hear me? Thank
Yes.
you, Robert. Thank you, Robert. That's a very interesting discussion that you've just finished off there on the biography of objects and what it means to have objects, not as things, but as representations of living cultures. And, you know, these are not just objects that we see and visually gaze at in museums, and that's a very important point. I want to pick up from that. That's a very interesting point. So my name is Njabulo Chipangura. I'm an anthropologist. I work at the University of Manchester Museum, which is part of the University of Manchester. And I'm more like an Africanist. My work revolves around carrying out provenance research and biographical research on a collection of African cultural heritage objects that were collected. I'm using the word collected very carefully, because in an African context, these living, they're not even objects, they're living cultures. They were collected at the height of colonization, at the height of the expansion of the empire to most African countries. So consequently, African objects were appropriated, they were looted, were dislocated from their original context and placed in ethnological museums like Manchester Museum. So my talk is going to be about a kind of problematic histories of collecting African cultural heritage objects and placing them in museums as objects of the ethnographic and aesthetic gaze in the absence of understanding the biographies or the meanings of this living African cultural heritage. But I'm going to specifically speak on a very topical issue, which I think most of you here know, about the Benin bronzes that were looted by the British in 1897 in the infamous punitive expedition on the Kingdom of Benin. So I'm going to share my slides and talk through my slides and the work that I've been doing. Hope you can all see my slides. So my work, my ongoing work at Manchester Museum looks at a collection of Benin bronzes that were looted from the Kingdom of Benin in 1897 by the British. So these so-called bronzes, they're bronzes, but there are many other cultural objects that were collected from the Kingdom of Benin in 1897 by the British punitive expedition. So in total, I think close to 4,500 objects were dislocated from this kingdom in Nigeria, and they were taken to Europe, to the UK, and they were sold off on the market by most ethnological museums in Europe. They've got Benin bronzes, and the bronzes also comprises of other cultural heritage material like the Benin tusk that you can see on the picture there. So just another context to the work that I'm doing. So the Manchester Museum is part of the University of Manchester. We have more than 35,000 ethnographic objects from different parts of the world, mostly areas where the empire was moving to colonize Africa, Americas, Oceania, Asia, and picking up from what Robert said, a collection of ancestral remains, which I don't call them human remains for the purpose of trying to respect them, respect and rehumanize them, because these ancestral remains were dehumanized hundreds of years ago, and they're still living within museum basements with no context, with no provenance. So we're making a clarion call to rehumanize these ancestral remains by repatriating them back to communities of origins. So the African collection is the biggest. There's more than 12,000 ethnographic objects, and rightfully so. Africa had plenty of these British colonies, and that's why we have many of these objects from Africa at Manchester Museum. So my work sits around doing provenance research on African collections and collaborating with communities of origins. And these communities can either be diasporans of African heritage who lives in Manchester, or originating communities in African countries, to try and understand the biographical meanings of these objects in the absence of repatriations, which have become a very scary concept on many European museums, because in most cases, communities would not even know what we hold if we don't tell them what we hold, right? So perhaps without being scared of repatriating, collaborations with communities will give us even more biographical meanings to these objects, and we can co-produce new narratives with communities to represent their cultural heritage in a more sensible way, unlike the case now where these objects are just frozen, static, and lifeless in museum glass cases. So a particular example is this ivory tusk. So this ivory tusk is part of the Benin loot that we hold at Manchester Museum. In total, from a provenance research that was undertaken in 2022 by my predecessor, Stephen Walsh, we have 9 objects that came from the infamous loot of 1897 of the Benin bronzes. These 9 were donated or were transferred to Manchester Museum from Southwold Museum in 1939, including this tusk that you see on the picture. So that tusk used to be on the courtyard, the royal courtyard of the Oba, who was dispossessed by the punitive expedition in 1897. It's quite representational. There's a lot of symbols, religious symbols, and it was in our museum for a long time. It was on display before we start thinking about how can we ethically display looted cultural heritage objects in museums. Because before that, this was just presented as a big African elephant tusk from Benin, but there was no context whatsoever to the visitors on how Manchester Museum acquired this elephant tusk. So what I did when I was appointed in 2022, I deliberately said, let's give a bit of context to this object. Let's tell the story to our visitors. Let's tell them how this tusk was acquired. And we put in a new inscription on the pedestal close to the tusk, telling the visitors that this object was looted in 1897 by the British as part of the punitive expedition. What do you think Manchester Museum should do with this object? What do you think? And then 90% of our visitors, through an open book approach, said, please take back this object back to Nigeria. It doesn't belong to Manchester Museum. It doesn't. It was looted. We were obliged. We removed this tusk from display. We took it to the basement, where right now it's awaiting repatriation to the Kingdom of Benin, to Nigeria, right? Amongst the other 8 Benin bronzes that we have. So my point here is about truth-telling. Repatriations must be preceded with an act of accounting for what we hold as museums. The museum world is quite big, it's huge. Manchester Museum, for example, we're the biggest university museum in the UK. with more than 4.5 million cultural heritage objects. That you would never know if I, as a curator, don't tell you about the statistics. These objects are hidden away from the public, more so from communities of origins. So what I mean is that when you want to do any form of repatriations, then you must be very proactive. You must be proactive, not necessarily waiting for claims to come from communities, because these claims might not come. These communities might not know. In Africa, for example, communities don't even know that Manchester Museum has more than 25,000 African cultural heritage objects. They don't know. They don't know. If I, as a curator, don't take the responsibility to outline, to tell, to show what we hold. So this is the same case with the Benin bronze, the Benin task that you see on the picture. We openly told the story to our visitors, and they contributed their thoughts on what we should do as a museum, beyond curatorial expertise, beyond disciplines of anthropology and archaeology and the other so-called museum disciplines. Knowledge production must be shared, and museums must practice co-curation, co-production, working with either diasporians whose heritage is contained in European museums or originating communities from Africa whose heritage is contained in these museums as well. So Manchester Museum has been part of greater conversations around the repatriations of the Benin cultural heritage material. I was involved in a project called Devolving Restitution, which was led by Professor Dan Hicks of Oxford University under Pitt Rivers. So the project brought together museums in the UK that have African collections, and we're trying to establish provenances, because what you see in most ethnological museums in the UK is a similarity of African collections. If you go to Pitt Rivers, if you go to Manchester, if you go to Birmingham, if you go to Cambridge Anthropology and Archaeology Museum, we've got a similar kind of template of African cultural heritage material. Why? These objects were produced in numbers as living cultures. Clearly, they're produced as living cultures. They were never meant to be museums. They are living. That's why they are distributed across most of these ethnological museums. The so-called colonial entanglements. Go to Germany, for example. The Benin bronzes are also, they go to Belgium, go to France. They're exchanging these cultural heritage objects, which are produced in numbers as living cultures. So the Devolving Restitution project was meant to kind of put a spotlight on African cultural heritage objects that were collected or appropriated during colonial period and contained in museums in the UK, conversations on how we can approach provenance research collaboratively amongst institutions with similar African cultural heritage material. The other museums that were part and parcel of these conversations were the Derby Museum, the Glasgow Museum, the Great North Museum, the Ontarian, Leeds Museum, National Museum, NI Paisley Museum, and Power Cotton Museums. All these museums, they say similar African cultural heritage objects that were collected at the height of colonization. I was also involved in this famous project called the Digital Benin, where colleagues in Germany started off to document objects, pictorial objects of Benin material that are located in different museums across Europe and in the US. So we as Manchester Museum, because we want to be open, we want to be proactive, we don't want to hide, we want to tell the truth on how many of these bronzes we hold. We contributed to this project, which is an open database. If you go to Digital Benin today, you see the whole distribution map of Benin bronzes across museums in Europe and museums in the US. So this in a way, it's an interesting project. I mean, most people have spoken about digital repatriation, how we can do that. I think for me, it's very interesting in the sense that the whole Nigerian community, either diasporians or Nigerians in the continent or in Africa, so they now know where these objects are sitting, and perhaps more repatriation claims will come forward as a result of this form of open disclosure, of allowing a digital database of looted cultural heritage material to be seen by almost everybody. So these claims can come now from these active approaches of disclosure method. Lastly, there has been a store in Benin bronzes conversations, because a year or so ago when President Buhari, the outgoing president of Nigeria, left office, he made a declaration that museums in Europe are not supposed to return these so-called Benin bronzes to the National Museum Commission of Nigeria. Rather, they were supposed to return these bronzes to the Oba, who's the rightful descendant owner of these bronzes, whose father, Oba Emanuela, was disposed in 1897. So most museums in Europe, they have some bilateral form of agreements with the National Museum Commission of Nigeria, where they simply transfer. I think 2 weeks ago, there was a very interesting case of a transfer of 17, 18, 19 Asante gold objects from the Victoria and Albert Museum and the British Museum to Ghana, a short-term transfer of objects. And there was an outroar, big uproar, like by most African diasporans. And how can museums in Europe literally loan objects that were looted during colonization? So there's been this kind of debates on what can we do in terms of making sure that the Oba, he himself, gets the authority and the power to take control of these Benin bronzes that were looted in 1897. And then the other dilemma that came through again 2 years ago, there's a study group in the US called Research Study Group. It's a group of Black African Americans who argue that the Kingdom of Benin was responsible for selling slaves, transatlantic slaves. So the manila that was used to fabricate the bronzes was obtained in exchange of slaves. So from a moral point of view, these bronzes must not be returned to Nigeria because we have a lot of diasporans of slave heritage in the US or in Europe who are supposed to benefit from the bronzes. So they've challenged the Smithsonian Museum, I think in court 2 years ago, that what they did when they returned was illegal. These bronzes are supposed to be seen as some form of shared heritage. I'll leave this as a kind of school of thought, as a kind of provocative question to everybody in the panel, what they think about this idea of shared heritage in view of these Benin bronzes. Thank you.
Thank you, Njabulo. Thank you very much. I think, okay, so we have about half an hour. We'll finish a little bit before 6 o'clock. That's the plan. I hope you have many questions, and there will be questions online, which if Kristin you will share with us. I would like to ask 2 questions. One is to the entire panel. The question is this. I think it was you, Evelien, who mentioned good provenance. Let's say this object was illegally exported from, say, Mexico in 1950. How does that impact provenance? Does that mean that the provenance is no longer good provenance, for example? But I'm interested in everyone's opinion.
Okay, so this exactly is of course the case in the Getty victorious youth. Until recently, we had this like 1970 rule as a proxy to legality. So everything has we entered a new phase, and from then on, everything is illegal if it doesn't have an export license or good provenance. Before that, it's okay. So you see this is shifting a lot. And of course, from the perspective of Mexico, that lost a lot of cultural heritage, or from the perspective of the Oba in Benin, or from the perspective from a victim of the Holocaust, 1970, of course, is not a clear cut. And you see this shifting in all fields, I would say. So I think that at the moment, that's the main question. It's very unclear, and norms are shifting, and that's why we need precedents and we need transparency in.
Yeah, I mean, I suppose my point is that there's a big difference, in my view, between stolen property and illegally exported property. It's still not clear to me in the case of the Getty bronze whether the claim by Italy is simply that it was illegally exported, or they're also claiming that it was stolen because it was found in Italian territorial waters, etc., etc. Now, provenance, in my view, has nothing to do with illegal export. Provenance is the chain of possession or the chain of ownership. Hence my question, does illegal export impact good provenance at all? I would argue that it doesn't, but I'm interested in your view. Isabel and Robert and Till, do you have a view?
I think in practice, probably, you know, the question of illegal export has a huge implication on whether a provenance is considered to be good or bad. Although, of course, you're right to say that actually provenance, as we understand it, technically, is only the chain of the ownership. But I mean, when sort of legal requirements and due diligence requirements include having to prove that the object is legally in the territory where it is, then that has a huge implication as to whether it can be marketed, sold, and so on. So in practice, the two are more linked than probably, you know, theoretically they might be and should be.
Robert?
Yes, I very much would agree. So if there has been the obligation for having an export license and you do not have this export license, then you do have not good titles. So I would say there is no good provenance. So there is a missing link in the chain of provenance, because at the certain, of course, 1950 is, you know, as Evelien said, it's a tricky thing, because the 1970 UNESCO Convention does not work retroactively, as does international law, doesn't work retroactively. So you could say, even if there has been Mexican law of you need a national export license, there was no international recognition for this. So you could say, of course, with, you know, if you have a documentation that this object has been outside of Mexico already in the 1950s, and you have a documentation, I think, you know, let's ask the Mexicans, but I would say you are fine if you can prove this. However, if you do not have any kind of documentation, and then you try to sell it and you write private collection 1970, you know, there you have a problem. So I would say an export license is part of the provenance chain, and always, you know, like especially private collectors or the private market, they don't like export licenses, but they do produce a chain of provenance. So if you apply now for an export license, you know, you establish a chain of provenance that might help you in 20 years' time and 30 years' time of proving this chain of provenance. So I would say, yes, there is a strong link between export license and provenance.
And my second question is really for you, Robert. Gabu told us, you know, what the museum in Manchester is doing, which I think is commendable. We all know that there are many museums in Europe, in particular, that are well aware that certain works on their walls were looted during the Nazi era, and yet they do nothing about it. So my question is, can ICOM do something about it by blacklisting them, suspending them, excluding them? I know you don't speak for UNESCO, for ICOM, but so I meant ICOM. You don't speak for ICOM, but I'm just curious, because it seems to me so odd that you have countries, I will not name any, that have, you know, embraced the Washington principles and, you know, whatever, the Terence Declaration. Yet in the public museums of those countries, there are works that are known to have been looted, that have been subject to a claim, and nothing is done about it.
Well, in case of Nazi art, I mean, museums under the Washington principles, public museums, are obliged to do their homework. So they are obliged to do the provenance research. They get public funding for this. Our foundation mentioned earlier. So there is an obligation under the Washington principles. Beyond Nazi looted art, there's not a general obligation by law, but of course there is the ICOM Code of Ethics. And even the ICOM Code of Ethics, which is now, I think, the last version was revised, I think 10 or 15 years ago, but there are specific articles about what museums should do, that they should proactively, and this was mentioned earlier, proactively do their research. Of course, ICOM as an NGO can only, cannot force the museums. Of course, you could always exclude the museum, but to the best of my knowledge, this has not happened yet. But even the ICOM Code of Ethics that has clear language on return and restitution is currently revised, so there will be an even stronger code of ethics, not only on return and restitution, but of course on other current subjects, sustainability, gender balance, etc. But of course, this element, how to deal with provenance and restitution, will be even further laid out in the new Code of Ethics, I think, to be adopted in 1 or 2 years, depending on how the drafting is going. But the tendency is clear, a stronger obligation for the museums.
Thank you, Robert. Okay, I would like to invite questions from the audience. Yes. Yes.
I'm Mark Dodgson. I'm Secretary General at the British Antique Dealers Association. The question of the ICOM Code of Ethics, Dr. Peters, interests me. The current wording in the code says due diligence in terms of acquiring collections. Due diligence in this regard should establish the full history of the item since discovery or production. I think most people in the art market know that most cultural property, the vast majority of cultural property, does not have paperwork, history very much attached to it. Many things, as we know, have been in circulation for hundreds, if not thousands of years. Do you think there's a possibility that the ICOM code might reflect a slightly more nuanced approach to what appears to be a rather inflexible statement about the requirements for having a full history?
I mean, it depends very much on the object. Very often, the documentation is not as bad as it seems in the beginning. And of course, there is the obligation that museums should publish what they have. And even you mentioned the second-hand car, the second-hand car. There you have documentation, and with art objects you do not. I think this is something we should work on. So I would not say weaken it, but make it even stronger.
But you can't create documentation where it doesn't exist.
This is true, but very often you can do research, and I'm surprised how often documentation has been found. But of course, there always will be the difficulty of having a full chain of provenance. There never will be a full chain. You always might have difficulties in providing evidence for certain periods of time.
Thank you.
Next question.
Hi, I'm Charlotte Joy. I'm from the UK UNESCO National Commission. I have a question for all of you really about the difference between the ownership relationship of art taken during the Nazi period and the colonial period. And it relates to the ideas that we talk about stories and how that art was appropriated and then used within museums in the West to tell certain stories, which is part of the restitution demands. So, and I may be wrong here, but in Nazi looted art, the art didn't have that same sort of kinship relationship, often wasn't ancestors, as we spoke about, etc., was used in ethnographic museums to tell very problematic, racist, etc. stories. So what needs to be returned are the objects, but also undoing the harm, which takes me to the question, which is about visibility and creating these vast digital archives. And a lot of the anxiety around AI, around intellectual property rights, and around, are we potentially in a hurry to create these vast archives to create visibility to then allow return? But that might be storing up all sorts of problems in the future in terms of ownership around people's own heritage, storytelling, etc.
Who would like to address that? Yes, of course.
I also see just because Pierre, you may not see that I think Dr. Chipangura has been trying to intervene as well. So maybe I don't know who wants to respond first, but I just see him in the back.
Yes, it's typically Njabulo.
Thanks so much. Can I just quickly respond to Charlotte's question, which is very interesting around the visibility question and the creation of all these big digital archives and that. So for me, I think I spoke to the Digital Benin project, which is very interesting in terms of access and stuff. But I think it's also deeply problematic in terms of how communities of origins would not necessarily have the means and the mode, especially in Africa, for example, in Nigeria. The database is very nice, it's very big, expansive, but the cost of data, just cost of data to access those huge files of pictures on that database, it's quite difficult, it's quite challenging as well. So in as much as we think we're creating visibility through photographing and uploading visual images of these objects online to make communities access them, we might be creating a new digital divide because these communities of origin, they might not have the means and the mode to access the data sets that are uploaded on these digital platforms or on these big archives that we are creating as a form of digital repatriation or as a form of facilitating access to originating communities. That's just a question, a response to what Charlotte was saying about visibility and what it means to have these new archives that we're creating in the era of AI and other visual methodologies.
Yeah, maybe I can just add that it reminds me of also a point that was made before. There are, of course, regulations that had the UNDRIP, the United Nations Declaration on the Rights of Indigenous People, say clearly not only restitution, but also a right of control and access. So the right of control of communities to their own cultural heritage, so participation, someone else. So is extremely important in these decisions on people's cultural heritage. So this I also wanted to point out because someone said it's always the idea there should be a new Washington Principles for colonial takings, but there are over 20 UNGA resolutions, for example, in this field already. There is the UNDRIP, there are many. There is the ICOM ethical code. So there are already many regulations actually.
Can I just
me and the storytelling, because stories were told in and I think, you know, those stories, in my opinion, have value in themselves. And, you know, if I was asked, you know, how to deal with that, because some of those stories, of course, are, you know, can offend people today. But provided it was what the story is clear and it's clearly recorded who wrote that story and at what time and what was the context, I think those stories are worth preserving.
Yes, no, I just wanted to make one point about well, 2 points really. One is what Dr. Peters stressed very well earlier is time, which you've just alluded to, that, you know, essentially rushing into decisions that may turn out to be wrong is not always wise. The second point is, I think when you compared the sort of context of what happened to looted objects in colonial loot versus Nazi confiscated art, I think it's very important to remind ourselves that the Nazi looted regime, the moral framework, is the most developed for a reason. it is because it was the largest ever looting that took place, that a group of people was ideologically declared not to be valid to own anything and to own culture, and was stripped of all these assets on such an industrial and to a horrific scale that this was the first moral framework of dealing with a category. While, you know, there are some similarities with dispossessions, it has to be clear, I think, that this is, you know, a unique moment, and a unique moment in history, where, you know, that allows essentially us to say that the legal ownership is not determinative. So this is a huge step of saying moral rights override legal ownership. And I think to use that in an inflationary way brings equally a lot of problems with it. So I'm just cautioning here not to compare, you know, different things and to squeeze a square peg through a circle.
Kristin, should we look at a question, an online question, maybe, so that those who are online don't feel discriminated against?
There were a couple of online questions that we may want to pick up on. I did want to invite those who had there was Gary Nurkin and George Lederman of Withers, who had asked questions. If they want to unmute themselves and ask the question directly, they are welcome to. So George, please go ahead with your question on US law enforcement.
Yes, thank you, Pierre. I do not feel discriminated against, so thank you. And thank you all for a very interesting event, very informative. I'm at Withers in New York. As a former prosecutor in New York, I now litigate against the government in the area of art crime. And our government takes sort of a view that if there is a certain individual in the provenance, in what they refer to as the bad guy list, then that object is per se looted property, even in the absence of theft. I have clients who, if they have looted works, are more than willing to give the objects back. Yet, even in the absence of theft, they feel compelled to voluntarily relinquish the works, because if they do not, they may face the risk of individual criminal prosecution for criminal possession of stolen property. And more than that, they face the risk of reputational harm. Our government here takes the view that if you do not, or if you had not engaged in today's standards of provenance review, something which even they, the government, did not participate in, then you have not fulfilled your duty under the US law. My question to you is, what ways do you think there are to correct this imbalance in terms of people who are good faith but purchasers, and where the government is nevertheless asserting a claim on behalf of a foreign sovereign in the absence of theft?
Such a difficult question to answer, I think. I mean, I think it's the power of the state, which we see, you know, not just in the US, but in so many other countries. I mean, we talked about Italy. I mean, it's a form of blackmail, what Italy, other US museums. I guess this is a slightly different situation. This is, you know, they have an opinion, and they will basically ignore the rule of law by the sound of it, and go after people who have in their possession objects that might not have been stolen, yet in the provenance there is the name of a bad guy, as you call them, or as they call them, and that's a problem. I mean, in the case of the Persepolis relief that Till mentioned earlier, you know, what was his name? Bogdanov, who was after this relief, claimed that the dealer hadn't done his due diligence, when in fact, you know, the evidence that was uncovered later on was extremely difficult to find. And it's only because, you know, one knew where it was that one could find it. I'm not necessarily, I mean, I'm not answering your question directly, I know. I'm not sure that there is an answer. I mean, what panelists, do you have a question?
I know Mr. Bogdanos well. I worked with him and I work opposite him at any given time. I have 3 or 4 matters just of the kind I've explained. And yes, I don't know that there is a response. Perhaps the times will shift. But again, I think they rely on the fear of reputational harm in order to engineer a voluntary release of works in the absence of theft. So again, I appreciate your thoughts, and maybe one day times will change so that there is more of a requirement to demonstrate actual theft.
Thank you. Yes, Evelien.
Well, maybe I can just say that this is also exactly what I mean, that we need some kind of clearing system, let's say. At least, well, in the US, mostly you can go to court with these cases, but in Europe, it's even worse. You cannot. So there is no way that you can have access to justice. So that's why I think there is a vacuum here, and we need transparency, and we need some precedents where people that feel wronged or something can go to in some way. And so we have to balance it out. But I think in the US, the situation is a bit different. Also, I don't often, of course, I don't know if you're talking about antiquities or Nazi-looted art. Antiquities, of course, often is considered property, state property. There's these laws. So then it is considered stolen property under US laws. So it's a bit difficult to...
I think there's also a big difference between countries where the criminal authorities get involved very quickly, like Italy and the United States. In England, I mean, of course, you know, there is, I mean, obviously, you know, the police can get involved, but it rarely does when it comes to cultural property, relatively rarely. But in other countries, the criminal authorities are very, very prompt to react. France is another example. Do you have any thoughts on this?
Well,
yes.
Sorry. Sorry. So I think there are 2 developments under the law, and that's humanization, increased importance of human rights, court on human rights, the Getty is also an example, but also criminalization. You also see it under the new court regulation. You're committing a criminal offense if you don't have if you import looted objects. So that's also criminalization. I think it's becoming of increasing importance.
Another question, another online question?
Yeah, there was another online question. I see the person has unmuted himself, Gary Narkin. If you wanted to come back, because there's quite a bit of interest and discussion about the Getty, and I think it was a question about perhaps asking you to speculate a little bit about a possible appeal. Gary, did you want to ask your question, or should I just?
Sure. Getty has said that it will appeal the ruling in the victorious youth. And like the previous speaker, I too am an attorney licensed in New York. Do you think the Getty has an argument that it can make to have the decision reversed on appeal, given that Italy stated, well, this statute was found in international waters, and the Italian courts have said that it was not found within Italy itself, so that the Italian law of ownership would not apply. But Italy argued post-purchase by Getty that because the statue was exported from Italy without a license, Italy became owner of that statute. And since that is post-purchase by the Getty, isn't there an argument that the Getty can make on appeal that the statute should not be applied retroactively to what the Getty had purchased.
Okay, so my understanding, which may be completely wrong, is that Italy doesn't claim that they acquired ownership because the bronze was illegally exported. They claimed that ownership because they say that it was fished out of the water by Italians on an Italian boat outside, I think everyone accepts now, outside Italian territorial waters. Now, that to me seems like a very odd argument. I can't imagine why anyone would buy that argument, but obviously the Italian courts have. To my knowledge, whilst in certain countries like Spain and I think New Zealand, if you export a work of art illegally, the law says that the state immediately becomes its owner. To my knowledge, Italy doesn't have that rule in their rule book. So I don't believe that Italy can claim that it became the owner simply because the item was illegally exported. A thought that came to my mind is that if it is claimed that the Getty must return the item because it was illegally exported, given that it is not an Italian item, it was apparently, as I understand it, made in Greece. I question whether Italy had the right to basically stop this item, assuming that this is what they're saying, to prevent its export because it was exported, well, let me get this right. I think it was exported after Italy became a member state of the European Union. And effectively what they're relying on is the exception in the Treaty of Rome that allows member states of the European Union to impose export controls within the EU for national treasures. My question is can this be treated as a national treasure? And I would argue the answer is no, because it has no Italian connection other than the fishing boat, which to my mind is not a good enough connection. Now, of course, there is a question as to whether the bronze, as to where the bronze went when it left Italy. Of course, if it's true that it went to Brazil, and apparently it is a possibility, then of course this argument about the Treaty of Rome falls apart. But if it went from Italy to, say, France or Germany, then I question whether the Getty might, bring a case before the European Court, arguing that Italy has no right, or had no right, or would have had no right to stop this item because it's not an Italian national treasure. Sorry, what's the question? Did I say anything helpful?
Yeah, it was Gary there.
You did, yeah, I'm still here, I'm listening.
Does anyone else have a view, or even from the audience, or in the audience?
Well, I just wanted to add the BIICL case. We had an example, of course, of another case before the European Court on Human Rights, and that was confirmed there again. Italy, I think it was Italy. Also, but that was a Van Gogh painting, I think. So is that so there? And actually, there's also, I think, a ruling in the US where again it was a Van Gogh painting. Anyhow, the European Court on Human Rights said that the rules to declare something national treasure can also apply to these kind of works. So it doesn't mean that a national treasure has to be nationally produced. That's for certain, but I completely agree that the whole concept of national treasures, national patrimony is different.
Yes, and what I'm saying is I'm not talking about human rights here. I'm talking about the Treaty of Rome and the free circulation of goods within the EU. And in my opinion, the narrow exception, I think it was originally in Article 36, that allowed EU member states to impose export controls over national treasures. But to my mind, this is not an Italian national treasure. There was a case a few years ago about the Salvador Dali, which again, the Italians stopped from leaving the country. Well, I'm sorry, but a painting by Salvador Dali, how can it be an Italian national treasure? So anyway, I have a bee in the bonnet about countries that declare just about anything as national treasure.
You should have a look at the Maltese law.
Oh, of course,
Declares everything that is an artifact, I think.
As
Texas, I think so.
I
Yeah.
see. Well, in my opinion, that's illegal under EU law.
But it's true that the BIICL was a Van Gogh painting of a French subject, right? Of the gardeners. So
Exactly.
adding another layer.
Thank you. So my name's Cecilia Dance. I'm a solicitor and currently studying the art law LLM at Queen Mary. Dr. Campfens, you talked about the rise of extra-legal ethical frameworks in terms of restitution. So I was wondering, where do we go when presumably that relies on some kind of cooperation or goodwill from the other party? And so where do we go when that doesn't exist? I guess I'm thinking particularly of Russia and Ukraine, because I know it's something you've worked on. It's something I'm writing on at the moment. How do we get them to the table? And can those frameworks extend to countries which don't seem to want to restitute looted property?
Yeah, well, the ethical framework or the ethical model, I basically mean models like the Washington principles that are not based, that are actually based on the high moral standards of the current possessors, and and assuming this whole field is a matter of morality, not a law. And I think there should contradiction about Ukraine and Russia. That's a whole, I have not seen it in that perspective. I worked on that actually with Kristin on that report, but yeah, we did propose something. We did give a recommendation that relation to museums also, that there should not be a cooperation with institutions that actively endorse and work with or are part of the looting of museums in Ukraine and everything. So that's also kind of ethical model, I would say.
And well, we have time for one more question.
Yes, I would personally have a couple of questions, but perhaps I'll ask them both, and then you decide which one is relevant. We have the first one regards confidentiality, because of course it's very important in the work that you do. At the same time, we're talking about transparency, right, and the need to kind of tell people, you know, what could be a just fair solution, etc. So what I'm wondering is, in your work, to what extent does confidentiality, to what extent is it discussed once a resolution is found? Do you ever find your clients and both parties perhaps being willing to share their experiences, or is that a point that remains really important all the way till the end? Or if, you know, a good solution is found, then perhaps it's something that they may be happy to disclose. The other question I had that I found very interesting is, Robert, you mentioned replica, the issue of loans, etc. I've worked in restitution. I was somewhat involved in one restitution where there was a replica that was made. At the time, it was seen as an ideal solution. But years later, there is some perhaps animosity on the part of the community that had offered a replica, but perhaps felt somewhat forced to offer it in order to gain the original object back. Is that something that you see as well in your work? Is that often seen as a solution that is viable, or to the contrary, is it something that people are kind of objecting against?
Would you like to take the first question?
Yeah. I mean, confidentiality is extremely important in every case and everything we do, but and it always depends again on the case. But we had examples of settlements where I think, like, usually the receiving party is maybe more open to communication and press releases and so on than the let's say private collector who is giving something back or who is finding a solution with the other side. But on the other hand, we had cases where the current owner or the private collector was happy to communicate a settlement because it shows that, you know, he has the work has been researched. In many cases, we did our work and then we proactively approached the other party. So that's also an element that, you know, is good to communicate and also to maybe motivate other parties to act in a similar way. So I would say it really depends on the case. It depends on the collector, on the parties.
Address the replica point.
Well, I can try. I mean, you rightly said it really depends. I mean, once, you know, there was an agreement, I don't know what specific case you're talking about, but sometimes it's also the question, like, who gets the replica? Is it the claiming community, or is it the claimant, or the foreign country, or is it the replica that remains and the original object is returned? So this is, you know, two possibilities. And of course, it might be that, you know, after a certain period of time, there is or the understanding that the situation has been changed. Then, of course, it's the difficulty whether a solution that has been once reached, whether this stands as it stands, or whether there is a renegotiation necessary or possible. But in general, and it really depends on the very exact case, in general, I would say yes, it's an option, it's a possibility at least to consider in order to find a solution. I remember reading about a case about this was some islands in the Pacific, and they said, we do not want the return of ethnographic materials from a German museum. We want to have your data because we do not have the resources to maintain the object in the physical. We have, you know, climate change, the islands are drowning. We have difficulties even, you know, maintaining our own collection. What we want is access and data. So there's a joint project about this to put the data online, and the objects physically stay in Germany. There's also with, you know, the Benin bronzes where the title of ownership has been returned, but the objects remain in the current collection. So this is also an object. So I think there's a whole variety of possibilities and it really depends on the stakeholders involved.
I think this is the end. Thank you very much, the panelists first of all, and that includes Njabulo. I'm not sure if Njabulo is still online, but thank you, Njabulo, for participating from Manchester. Thank you everyone online for being with us, and of course everyone in the room. And thank you for the BIICL. I always get that wrong. For you know, being our host today.
Thank you, and thank you to all our panelists. Thank you to Restitution Partners for having made the event possible. And for those in the room, there will be some drinks, so please stay with us for a bit of extended discussion.
Thank you for an excellent presentation.